Okay, got another great question for divorce here. Looking for advice about having a binding mediation to avoid trial. Well, that's interesting because there's no such thing as a binding mediation. Mediation is the use of a neutral third party to settle your case or help referee settlement negotiations. They will create a memorandum of understanding if you do reach an agreement. You bring that memorandum to a lawyer, they write up the settlement documents for you, and they help you get divorced. Or if you're real sharp and you've got the time, you create the stuff yourself, fill out all the paperwork, and get divorced yourself. There are binding arbitrations and there are binding pretrial conferences, but there is no binding mediation because, by definition, mediation is just a negotiated agreement. A binding pretrial conference is when you and the other lawyer or you and the other party agree to have the judge give you recommendations for resolving the case, and you agree to be bound by those recommendations. The challenge with that is usually the judge's recommendations don't cover every little detail. At least it's the big ticket items, so it can be helpful. Alimony, perhaps child support, division of assets, etc. And you still have to work out the smaller issues. But there is sometimes a practical value in having a binding pretrial on either a specific issue or a series of issues in a case. The other thing I've seen is binding arbitration, although not nearly as much used in divorce, starting to be used increasingly. Binding arbitration is using an arbitrator. Think of an arbitrator as sort of a private judge, and you have a mini trial where you put on evidence with simplified rules of evidence. Lawyers are usually there representing you, and there's no jury, just like there's no jury with a divorce and a bench trial, but you have an accelerated discovery process, produce documents with each other, and then a simplified trial really at this arbitration process. And the arbitrator makes a decision for you or against you and decides the divorce issues for you or some subset of those issues. You can agree at the outset that those decisions will be binding on you and your spouse such that nobody can appeal them or change them. You're stuck with those decisions as if a judge made them. So there's really no binding mediation. There's binding pretrial and binding arbitration, and they have their place, but your mileage may vary. You've got to consult with a skilled divorce lawyer to know whether it's to your advantage or not. I'm a big fan of alternative dispute resolution. It can be a great way to save a lot of money and time and grief, but it's not right for everyone in every situation. Thanks a lot. For more, like, follow, and share. I'm Rayford Dalton Palmer, the divorce lawyer in Chicago.